Hello and good morning, everyone, and good afternoon to those on the East Coast. Thank you so much for joining us today. This is the latest episode in Venable's Ad Law web series. My name is Amit Rana. I'm a partner in the San Francisco office here at Venable. I'm a commercial litigator and co-chair of the class action defense practice. A big part of my practice is defending consumer packaged good companies in consumer class actions. And so I'm really thrilled to be talking about this topic today that comes up almost every day in my practice. I'll pause there and let my colleague Antonia introduce herself as well.
Thanks, Amit. Hi, everyone. Thanks for joining. I'm Antonia Stabile. I'm an associate with Venable's commercial litigation group here in San Francisco, and I work with Amit defending a lot of these consumer class actions that involve false advertising issues like the ones we're going to talk about today.
One of the reasons that I'm so excited to talk about this topic is that I know it's what in-house legal teams and marketing teams spend a lot of time thinking about. How do we label products in a fair and clear way that mitigates class action risk? And I know that creates some tension between the marketing teams and the legal teams often. And so I want to talk through where the lines get drawn by courts in a practical way. And we're going to spend a lot of time today talking about the front of label statements. It's the first thing consumers see, and it's the first thing plaintiffs' lawyers sue over. But I know that a lot of folks in the audience today aren't litigators. They're regulatory attorneys, in-house legal teams, marketers. So my goal today is to turn some of the evolving case law into practical rules of the road for those marketing and in-house legal teams. And so with that, why don't we jump right in? So today we're going to trace how the front of labels, the law regarding front of label statements has evolved over time in the Ninth Circuit. We're going to focus a lot about the Ninth Circuit today because it's a circuit where this law is the most dynamic and the most active. As all businesses, as most of the folks on the webinar today know, when you start selling goods in California, it dramatically changes the legal landscape and the risk profile for consumer class actions in particular. And given the plaintiff-friendly courts here in California, I expect that the Northern District of California here in San Francisco and the Central District of California down in Los Angeles are going to continue to be the hub of false advertising class actions. And so we'll talk about how the Ninth Circuit case has evolved over the last 15 years in this regard. We'll turn to how district courts are applying the law in day-to-day decisions, what's happening in the real world in these court decisions with language like plant-based and natural. You'll see where courts are drawing lines between unqualified claims and unqualified claims that survive motions to dismiss and those that don't. And we'll look closely at kind of how those qualifiers play into those decisions. We're going to talk a lot today about court decisions at the motion to dismiss stage. So I don't want you to understand anything we say today to be any reflection on the merits of these cases or their ability to get any of these cases certified. But as most of you know, getting an early exit on a motion to dismiss can be a game changer in these cases. Even if you have a case that you feel strongly that you will prevail on the merits, a plaintiff getting past a motion to dismiss opens discovery and can exponentially increase the legal spend. And so a lot of what we're going to talk about today is how we can escape these cases early on a motion to dismiss on pleading challenges. We're also going to look at some of the other circuits, the Second Circuit, the Seventh Circuit, and the Eighth Circuit. They all use slightly different language, but we're starting to see them converge on the same principles. And then finally, what I want to spend the most time today on is how do we extract practical drafting and marketing lessons from the case law that's out there. We want to talk about what this means for your business practically on a day-to-day basis. How do we draft and place qualifiers on labels that will actually protect you if you ever get a consumer class action? How do you align the front, side, and back panels to avoid contradictions? And how do you build usable internal checklist that will help you sign off on label decisions before the labels go out the door, and that mirror the way that courts are actually thinking about packaging. So to answer those questions, let's ground ourselves on some of the core issues and the standards that kind of govern all these cases.
Yeah, so Amit did a great job setting that up. But the core issue that we're going to talk about today is really, when does a front label statement require additional qualifying language? So, how much can a consumer reasonably be expected to rely on something on the front label, and when are additional disclosures needed. We have our little example here. Can you say 100% natural granola on the front label and then say on the back label that it has artificial preservatives? So we're going to address that today. And really, this issue comes up in every labeling case, whether it's food products, cosmetics, supplements. So yeah, we'll go through that. And most of these class actions are brought under California's consumer protection statutes, which are all governed by the reasonable consumer standard. Other states have different laws, but many of them are also governed by this standard. And so under the reasonable consumer standard, a plaintiff needs to show that a significant portion of consumers could be misled. So not just that the label could be misunderstood by some consumers, but we're looking at a significant portion. And depending on the context, a reasonable consumer could be the general consuming public, or it could be a group of consumers that product specifically targets. And that largely depends on what kind of product is at issue. But either way, the standard is going to look to how those consumers interpret the label.
So let's go all the way back to 2008. Williams versus Gerber was kind of the foundational case in this area. If anybody has practiced in this space over the last 15 years, you've seen this case cited by plaintiffs in almost every brief that they bring in consumer class actions. And the issue in this case is you see the front of the label, it says fruit juice snacks. You see pictures of oranges, cherries, strawberries. I think you have some peaches here. The challenge for Gerber in this case was that the product does not contain juice from any of these products. The product contains only grape juice, and the first ingredient is corn syrup, followed by sugar, followed by white grape juice. Gerber argued, well, any consumer can figure that out by just looking at the ingredient list. This is not hard for a consumer to understand what's in the product. The Ninth Circuit said that we disagree with the district court in this case actually dismissed the case. It agreed with Gerber and said, look, you can simply look at the ingredient list. Any consumer that cares about what's in this product can easily figure that out by looking at the ingredient list. The Ninth Circuit reversed, saying we disagree with the district court that reasonable consumers should be expected to look beyond misleading representations on the front of the box to discover the truth from ingredient list in small print on the side of the box. It drew a clear fault line in these cases that consumers should be expected to rely on quick front label cues, and that ingredient list and any other disclaimers on the back of the package or the side of the package should not be able to cure that. It's the quintessential front label governs rule, and that the back label can confirm the front, but it cannot contradict the front. For consumer brands, this was the case that really laid the groundwork to understand that ingredient lists are not a legal shield in most of these cases. They're supposed to support the story that you want to tell on the front, but reasonable consumers are not expected to look at the back. And this was the state of the law for over a decade for anybody practicing in the Ninth Circuit and frankly in other parts of the country as well, that reasonable consumers will not be expected to look at ingredient list, back label disclaimers, side panel disclaimers. They'll look at the front label, and that's what's going to control. And so we'll jump ahead to 2021 when the next iteration in this area of the law came out with Moore versus Trader Joe's.
Yeah, so over a decade after Gerber, we see this really interesting Moore versus Trader Joe's case, and the first real departure in the Ninth Circuit from Gerber. So this case involved a challenge to a honey product that was labeled 100% New Zealand Manuka honey. And plaintiffs said that this was misleading because the product only had about 60% honey that was actually derived from the Manuka flower. And this case is interesting because there's a lot of windup in the decision about the background on how honey's made, how bees forage on different flower plants, and how, you can't produce honey that's derived from a single flower. And the court really took all that context into account when it concluded that this 100% New Zealand Manuka honey claim was ambiguous. And basically, the court said, because this is ambiguous, a reasonable consumer would need more information before it could make a conclusion about the claim's meaning, especially the conclusion that the plaintiffs were pushing, which was that this product was actually derived from 100% Manuka flour. So it not only was this claim ambiguous, the court said that it wasn't deceptive as a matter of law because a reasonable honey consumer would know that it's impossible to produce honey derived exclusively from a single floral source. It's not something I knew, I buy honey, but but it's really like the context just really interesting. I think the biggest takeaway here is that this case really hinged on the court's application of the reasonable consumer standard, specifically to purchasers of Manuka honey, not just the general public. So it's really about the fact that people who buy Manuka honey in particular are aware of all this context about bees and how honey is made and how the honey is derived. And the court also emphasized that a reasonable consumer of Manuka honey wouldn't see a jar of honey that only costs $13.99 and expect it to be 100% Manuka. So, all this to say that this case was a high watermark for defendants, especially in the Ninth Circuit, which we know is more plaintiff friendly. And this case really gave defendants an opportunity to pull in all this other context, including price point and consumer knowledge, pop culture, and all of that just to clarify a front label's meaning.
I love this case as a defense practitioner. I mean, this is one of the great cases we love to cite. But it's so it's some of the language is so interesting and frankly questionable. I mean, the line that says there is some ambiguity as to what 100% means. Really? It seems like a pretty clear statement to me. And then the other great takeaway from this case from a defense practitioner is the court said we can go beyond the label even. We can think about what context a reasonable consumer will bring to their purchasing decision. And here they said a reasonable consumer will understand the foraging habits of bees, will understand how much a jar of Manuka honey should cost. So it's like I love it as a defense practitioner. I cite it in a ton of briefs, but really stretching the doctrine of what a reasonable consumer, what kind of context a reasonable consumer should be expected to understand when making their purchasing decisions. And as Antonia pointed out, kind of a high watermark for defendants because there was kind of this stretching of this the context that a reasonable consumer should bring to their purchasing decisions. And that jumps us forward a couple of years to the McGinity case.
Yeah, so 2 years later, we got an even clearer departure from Gerber with the McGinity case. So this case involved a challenge to the Nature Fusion label on a shampoo product that also had pictures of avocado. Plaintiffs said that this was misleading because the product actually contained synthetic ingredients. This is a claim that we see all the time in the Ninth Circuit with both food and cosmetic products. Whenever there's a term like natural, nature, plant-based, or similar terms, this is going to come up. And in this case, the Ninth Circuit said, when a front label is ambiguous, the ambiguity can be resolved by reference to the back label. And so here, even though Nature Fusion made some kind of representation about nature, it didn't make an affirmative promise about what proportion of ingredients were natural. So the court said, since we don't know what Nature Fusion means based on the front label, you turn over to the back label. The back label says things like smoothness inspired by nature, smoothing system with avocado oil. And based on those back label representations, which clarified the Nature Fusion claim, the court said the product wasn't making a claim that it had no synthetic ingredients. Of course, this is different from the many cases out there where a label says something like 100% natural or all natural. When you have something like Nature Fusion, it's more ambiguous and consumers could be expected to look to the back label. So I think the key takeaway from McGinity is that when you're using like these more vague marketing terms, like fusion, inspired by, crafted with, those types of claims can invite consumers to review the back label. And this McGinity case, I mean, this was even stronger than the Moore versus Trader Joe's case for defendants because it just set out this clear standard of when something can be ambiguous on the front label. And under the term ambiguous, like a lot of different things can be ambiguous.
Yeah, and the takeaway, I mean, that's exactly right, Antonia. The takeaway here is that there's a very clear definition of what ambiguity is. More than one plausible meaning. Any lawyer worth their weight can come up with multiple plausible meanings of any statement, and it opened the floodgates on motions to dismiss to argue that the back label, the side panel, the ingredient list should all be taken into context. And the one interesting thing I'll point out here is this was a decision written by Judge Gould, and that'll become relevant later. But Judge Gould wrote this decision in 2023, and and the result, frankly, was, as I said, kind of an opening of the floodgate for every defense counsel to argue that front label claims are ambiguous and that the court must consider ingredient list, back of label claims, qualifiers, side panels, etc. Um, so let's pause there for a second just to look at this visually, because I think the Ninth Circuit's journey on these front label claims really kind of tells a story. You know, you start in 2008. This is the consumer protective baseline. If your front of package is misleading, you can't fix that with fine print on the back. The court basically said consumers are going to look quickly at the front label and should not be expected to look on the back. And there wasn't really much wiggle room on that standard either. That principle held for more than a decade and shaped nearly every class action against food, cosmetics, and CPG brand product out there for the 2010s. Most of the folks on this call probably, if you made marketing or labeling decisions in the 2010s in this space, you probably based it off of Williams versus Gerber and the decision that consumers cannot look to the back or the side panel for qualifying language. But then we moved to Moore versus Trader Joe's in 2021. Courts softened the line quite a bit. Context matters. Again, product was 100% New Zealand Manuka honey. Apparently the bees didn't get the memo because only about 60% of the product came from Manuka honey or Manuka flowers. Rather than call it deceptive, the court said that reasonable consumers bring some background knowledge to their purchasing decisions. Kind of a reasonable outcome, but it opened the doors for defendants to argue that industry facts, pricing, consumer understandings, context, knowledge, they all clarify the phrases that we see on the front packaging of products. And then we go to the McGinity case, and the court reasoned that additional context is required anytime there's an ambiguous statement on the front and has this very clear standard of what ambiguity means, more than one plausible meaning. And in those circumstances, the court should look to the back. So you've seen quite a bit of a retreat from Williams versus Gerber that drew a fairly distinct line between the front and the back to, context matters and more. And then McGinity, back label context, side panels, they all are part of the analysis when there is more than one plausible meaning to the front statement. So after McGinity, I mean, for in-house teams, for marketing teams, this was the moment where it inspired all sorts of creative marketing claims, plant-based, plant-derived, nature. Suddenly, all these claims seemed much safer because the courts might read them alongside your ingredient list or whatever else you want to put on the back of the package. And so that was a Ninth Circuit, appellate court decision in 2023, and I think it changed the landscape quite a bit in the short term, at least, for in-house legal teams and marketing teams. But this evolution set the stage for a correction. I think by the court stretching this concept of context to a pretty liberal understanding of what context means, courts were largely finding that reasonable consumers should evaluate the entire package in a lot of instances, and really walked back the original foundational case, Williams versus Gerber, and its consumer kind of protectionist core quite a bit over that decade. And that's where the next case, Whiteside versus Kimberly Clark, comes in. It really swung the pendulum back and walked back at this evolution, this trajectory that we saw in the courts over this decade. And so
really quickly, Amit, I was just going to add, before 2021, before we had, or the Moore decision, we didn't have a whole lot to work with as defense counsel too. We had the Gerber case. There wasn't a lot of district court decisions that we could work with to kind of go past the front label. And then all of a sudden we start getting these really positive district court decisions interpreting McGinity and Moore. And so like all of a sudden we had this like, okay, we can kind of make these arguments, and then Amit, you'll explain Whiteside, but that's kind of the landscape we were dealing with.
Yeah, and so Whiteside is kind of the course correction here. It tells us when courts may read beyond the front panel, but more importantly, or just as importantly, they tell us when courts should not go beyond the front panel and draw some pretty clear lines. It was almost a perfect case for an application of this because there were two versions of the product that were at issue. These were Huggies baby wipes, and Huggies labeled them as plant-based wipes. But there were two versions of the product. One had an asterisk after the plant-based claim, and that asterisk said that it was 70% plus plant-based by weight. There was also a second version of the product in the record, and that just said plant-based wipes without any sort of qualifying language or asterisks. The easier decision, I think, for the court was on the asterisk claims. The court said these were not misleading as a matter of law because the presence of an asterisk puts a consumer on notice that there are qualifications or caveats on the front or back of the label. In this case, the qualification was on the front, proximate to the plant-based wipes, which I think helped, but it did open the door for an asterisk or an arrow to invite consumers to look for more context, whether it's on the front or back of the label. The harder decision or the harder product to decide on whether it was deceptive or not was, I think, the unasterisked plant-based statement. The court here, and again, note, this is Judge Gould who wrote the McGinity decision just last year. He did not reverse McGinity. He actually, frankly, explicitly reaffirms McGinity and says a product's back label may be considered at the pleading stage if the front label is ambiguous. But I do think that Judge Gould and the Ninth Circuit saw this flood of district court cases almost reflexively looking at the context on the back label, the side panels, and wanted to walk that back a little bit. And so, it changed the idea of what ambiguity is in my mind. And so while it confirmed that the back label can be considered if the front label is ambiguous, it said that a front label can be unambiguously deceptive even if it may have two possible meanings, so long as a plaintiff has plausibly alleged that a reasonable consumer would view the label as having one unambiguous and deceptive meaning. And if you have to take a double take on that, you're probably not alone. I mean, the most obvious and commonly understood concept of ambiguity means more than one plausible meaning. But the court here is saying that's not enough to find ambiguity. Just because you have more than one possible or even plausible understanding of a label, it does not mean that the court should be looking at the back. It drew kind of a new standard. It redefined ambiguity and drew a new standard. And it said a front label is only ambiguous enough to have to force a consumer to look at the back when reasonable consumers would necessarily require more information before reasonably concluding that the label is making a particular representation. So I think what Judge Gould did here was he did not want to reverse himself on his prior decision from a year ago. He kept intact the standard or the test that ambiguity should lead to further investigation on the back or side panel, but he's come up with an entirely new definition of what ambiguity means. It is not that there are more than one way of understanding a label claim. A front label is only ambiguous when a consumer necessarily or must require more information to understand what that representation means. It's a stark retreat from where we were with McGinity. And I think that was intentional. I mean, I think Judge Gould didn't like the outcome from the McGinity decision, didn't like what he was seeing in the district courts, and wanted to walk it back without reversing himself. And so a couple of takeaways to take away from the Whiteside case. One is put your cures on the front. If your word choice is inherently broad, plant-based, natural, eco, sustainable, pairing it with a visible proximate qualifier on the front that allows a consumer to understand exactly what you means is going to be an easier argument to get out of the case on a motion to dismiss. Whiteside effectively is going to reward defendants who make the scope of the claim readily apparent on the front of the label, where consumers will look immediately. The second part of it is that the qualifier should be conspicuous and on the front. So it arms us with a rule, like a motion to dismiss win, when we can show that the front label itself shows the limitations and that the rest of the package matches that signal. And so for design guidance, always think about what the front label, what the net impression of the front label is, and make sure any qualifying language is upfront, proximate to any vague descriptors you might want to use. You want to make sure you also mirror language across panels. If you're going to say something about what plant-based means on the front package, you want to almost verbatim repeat that on the back and side. You do want to avoid kind of synonymous or closely matched language that plaintiffs might point out creates some contradictions. And then again, if you're going to have some qualifying language on the front, make sure you have substantiation on the same terms as the qualifier. And what the plaintiffs, where we're seeing the plaintiffs kind of move is they're trying to attack qualifiers. They're saying it's too small, it's too far, it's too vague. Your font is different. Your front label is giving a contradictory impressions of what you're really saying here. Whiteside lets us meet those attacks pretty clearly because it had this clear language about the power of a front label qualifier. And then from a litigator's perspective, we can use Whiteside at the pleading stage to kind of create a little bit of a playbook. You want to always argue that there's necessary ambiguity, not just possible ambiguity. You want to frame the front text as a kind of a phrase that a reasonable consumer can't interpret without further context. And that ambiguity will allow you to bring in back label or side panels into the conversation. But again, it's got to be more than just possible ambiguity. It's got to be necessary ambiguity. And then again, point to conspicuousness and proximity of any qualifiers. Show where the qualifiers sit, size, contrast, that all matters. And then emphasize alignment across all panels. You want to make sure you note that the back or side panels confirm the front panel. There's no contradictions. That's all going to help support a quick, easy dismissal in these cases. And so while Whiteside doesn't give us a clear free pass to introducing context, it gives us a path and an idea of how we can show the courts that additional context is necessary, and it ensures that the rest of the package gets before the court and that context is considered as a whole. So let me pause there for a second. Many of you are joining in California, New York, other jurisdictions where you're hoping to get CLE credit. So there is a secret CLE word. The CLE code word today is label 2025. Again, that's label 2025, no spaces. And yeah, and as you see, my colleague dropped in a link to the CLE form. So, okay, so Whiteside set some ground rules on how district courts should be interpreting front label claims. Let's look at some practical kind of hypotheticals on how this is shaking out in district courts. Whiteside it drew this line between front label clarity and kind of contextual ambiguity, but the doctrine's only really as good as how judges apply it to actual packaging, and so that's where these district court decisions come in. And over the last year, we've seen quite a bit of activity in the district courts testing Whiteside, taking real-world phrases and saying whether they're ambiguous, unambiguous, whether further context is required or not. So I want to take a look at a few representative outcomes. Each one of these cases are real cases from district courts that apply Whiteside. We have a lot of really great clients in the audience today. I don't want to put anybody on the spot, so I've anonymized most of these product labels to kind of give you just the relevant front label and back label cues that kind of drove the decisions. So I don't want to name any brands or put anybody on the spot here, but these are real cases. Real judges have decided these decisions. So let's look at the first example here. So you have a dog treat product here that says in big bold letters, made with real chicken, pork, and duck. You see some animated kind of cartoons on the front that indicate that there's real meat in the dog treats. And then you have a line that says dog chews made with vegetables and chicken. Plaintiffs argued that this was misleading because the product is actually just vegetables and wheat flour with a relatively de minimis amount of actual meat, even though there is real meat in the product. Defendants argued, well, anybody that cares about how much meat is in this product can easily figure that out by looking at the ingredients, and saying something is made with chicken, pork, and duck is not a representation that it's primarily chicken, pork, and duck. And so this was a case that the court actually said that the front label was ambiguous, and that a consumer would necessarily need additional information to figure out how much meat is in this product. And the quote from this case was, "This is exactly the situation where a reasonable consumer would necessarily require more information before concluding how much meat the product contained." The court said, because it was necessarily ambiguous, we can look at the back of the label. The ingredients clearly lay out what the ingredients are, in what order they're in the product, and this is not misleading as a matter of law. So a good defense decision on this product based on the made with qualifier on the front package that made the product necessarily ambiguous. Excuse me. Next, we'll look at a sleep aid that very prominently on the front label said, helps you fall asleep naturally. And plaintiff's theory of the case here was the term naturally on the front label implies to reasonable consumers that the ingredients are all natural. And the ingredients included synthetic dyes, synthetic colors that were in the product. The court here said, and defendants argued, that helps you fall asleep naturally does not tell you anything about the quality of the ingredients. It tells you the process by which you might be falling asleep. The court said, again, it was ambiguous, that a reasonable consumer does not necessarily know what you mean by naturally, would necessarily require additional information if they had questions about the ingredients in this product, and would look at the ingredients on the back, can clearly see that there are synthetic food dyes in this product, and this is not misleading as a matter of law. Again, the front label was necessarily ambiguous, forces the court to look at the entire context of the product, including the back label, and the back label clearly discloses what the ingredients are, not misleading as a matter of law. The interesting thing here was that the court distinguished other cases where the term natural or naturally were used to describe ingredients specifically on the front, and the court in those cases have come out the other way largely and said, when you're describing ingredients or the product generally as natural or naturally, then it is not necessarily ambiguous. And we've seen a ton of activity on the natural, all natural, plant-based, natural derived, plant-derived claims on the front of pack. But in this case, because it was used in a more ambiguous way, the court said consumers would look at the back, and that the ingredient list made it so obvious that there were not all natural ingredients in this product, such that no reasonable consumer would be deceived, and dismiss the case.
Yeah, I mean, this case strikes me as an outlier. Most of the time when we're seeing natural and naturally, we are not getting decisions saying that that's ambiguous. So I think just, a little caveat, something to note about this case.
Yeah, exactly. And the court pointed that out, that, we have to distinguish the context in which the naturally word is used on the front label, and distinguish it with when that term is used more broadly discussing the product and the product's ingredients. Here, helps you fall asleep naturally did not necessarily imply the ingredients were natural or that the product was natural, and consumers necessarily needed more information to understand how that term is used on this product. It's exactly that ambiguity that required the court to look at the back. So let's look at a couple examples where the court did not dismiss claims. And so you see a supplement product here where the front product says 5 milligrams, 50 capsules. The plaintiff basically said, well, you need 2 capsules for 1 serving size, and so you don't actually have 50 milligrams of 50 capsules. You have 50 capsules of 2.5 each. the court here says a reasonable consumer should not, in this instance, be expected to look at the back. The representation of dosage amount on the front label without qualifying serving information may be considered unambiguously deceptive to survive a 12b6 motion. So again, here, the court did not, even if there are multiple plausible understandings of what these terms meant on the front of the package, the court did not find that a reasonable consumer would necessarily need more information to understand the product's representations to say that there are 50 capsules of 5 milligrams here. So this was, even the back label could not come into context here, and the court denied the motion to dismiss because it's unambiguously, plausibly misleading based on the front label claims alone.
Yeah, in this case, I think is a good example of somewhere where a front label asterisk or qualifying language would help. If it said 25 servings or 2 capsules per serving, on the front label, then perhaps that would have been enough.
Precisely right. And we go back to Whiteside and we see that the qualifying language, the asterisks, the qualifying language on the front will almost always save you in these instances. And so a good learning lesson from this case. So the last kind of hypothetical district court case that I want to talk about is a hypoallergenic petroleum jelly product. If you look at the back, at the very bottom, you see fragrance. Plaintiff's theory was that fragrance is a well-known allergen. You cannot call your product hypoallergenic and have fragrance in the product, and you cannot hide the inclusion of the fragrance on the back panel. Again, the court said that reasonable consumers would not be expected to look at the back label here. It is improper for the district court to select between competing plausible interpretations of an ambiguous term. So again, we go back to that Whiteside standard, the walking back from the McGinity standard, two plausible interpretations of a legal statement is not enough to create ambiguity. You must necessarily require additional information to understand what the product label is saying. Here, the court said that was not present. The reasonable consumer is not expected to look at the back of the label, and it is unambiguously misleading based on the front label to survive a motion to dismiss. So you see cases go kind of both ways. One of the challenges I've seen from Whiteside is that Whiteside redefined ambiguity in such a I hesitate to use the word nonsensical, but kind of it just came up with a new definition of ambiguity that does not match how common people, regular people, reasonable consumers, frankly, think about that term. And so district courts are still grappling with how we're going to understand what an ambiguous label statement means and when it is necessary for a consumer to expect more information such that they're going to look at the back label. But we do see some fault lines coming here, and kind of the fault lines that we see most helpful are on qualifying language on the front, asterisks on the front, or something that is so ambiguous that a consumer does not understand what you mean, such that they're going to need back label context to help them understand. So with that, why don't we take a quick look? We've been talking about the Ninth Circuit so far. Not all these cases are brought in the Ninth Circuit, so I do want to talk briefly about kind of what we're seeing the other circuits do. And for that, I'll turn it over to Antonia.
Yeah, so the Ninth Circuit continues to be the hotspot for these class actions, but we are seeing a lot of them filed in New York. And this is largely due to New York's hefty statutory damages on consumer protection claims. And I'll try not to get too bogged down in all this case law since we're running a little short on time. But basically in the Second Circuit, we're seeing a similar approach as Gerber. Reasonable consumers are not expected to look to the back label to correct a front label misrepresentation. And that's going to be the law really in every circuit that we're seeing. But the Second Circuit it appears to be more willing to look at the entire context of a label. And instead of using this, ambiguity test set out in McGinity and Whiteside, the Second Circuit is willing to consider the entire label as long as the front label claim is not affirmatively inaccurate. And so I think that's a little bit of an easier standard for defendants because we don't have this ambiguity issue that we have now in the Ninth Circuit with Whiteside. So again, the affirmatively inaccurate standard, just a quick example in the La Rosa case that involved a ovulation kit, an ovulation test that said it was 99% accurate. The plaintiff said that that was misleading because the tests didn't actually test for ovulation. They tested for surges in the consumer's luteal hormone. And the court just looked at that language, 99% accurate ovulation test, and said, well, that's not 100% wrong, so it looks to the side panels, the back panels, which disclosed that the test was testing for this luteal hormone and not actual ovulation. And that's how the court kind of determined that that claim was not misleading. But the court still is, the Second Circuit cases are still following the McGinity test. They say asterisks can cure an ambiguous claim, and at least one district court in New York has expressly applied the McGinity ambiguity test, finding that a carbon neutral claim on the front label was ambiguous.
And the reason I think the Second Circuit decisions are so interesting here is, as we discussed at the beginning, so many of these cases are being brought in California because of the plaintiff-friendly courts out here. We can do a whole nother webinar, and maybe we will, on damages theories, but a lot of plaintiffs have latched onto statutory damages under New York's general business laws. And so we are seeing, a slight shift towards more of these cases being brought in New York. And so the Second Circuit law that mostly aligns with maybe a little bit more defendant friendly in the Second Circuit. It's interesting as plaintiffs kind of thread that kind of double-edged sword where they think they're going to be able to get statutory damages in New York, but maybe have a higher pleading standard to get past a motion to dismiss in the Second Circuit. And so interesting evolution of the law in the Second Circuit that we'll continue to monitor.
Yeah, that's exactly right. So the Seventh Circuit is interesting too, because here we had a rejection of an ambiguity rule before McGinity even set out the ambiguity rule, before McGinity and Whiteside. So in the Seventh Circuit, we have this Bell versus Public Supermarkets case where the district court had crafted its own ambiguity rule and said that you can look to the back label to cure an ambiguous front label. And there the claim was 100% grated Parmesan cheese. Basically, the district court said that could mean 100% grated, 100% Parmesan, or 100% cheese. So a reasonable consumer would look to the back label to get more information. But the Seventh Circuit rejected that ambiguity rule and expressed concern that such a rule would encourage deceptive advertising. So while the Seventh Circuit hasn't expressly considered McGinity and Whiteside and this ambiguity rule that we see in the Ninth Circuit, this decision really does suggest that the Seventh Circuit is going to align more with Whiteside, and that ambiguity won't be a safe harbor for marketers in this circuit. And finally, just quickly, the Eighth Circuit, we don't see a ton of class actions filed here, but the Eighth Circuit similarly follows Gerber, and at least one district court case in the Eighth Circuit has indicated that the Eighth Circuit would be receptive to an ambiguity rule. That case was a all butter loaf cake representation, and the court said that's ambiguous because obviously, a cake isn't all butter, so what does the all butter mean there? And ultimately held that claim wasn't misleading as a matter of law.
And so that brings us kind of full circle on what we've been talking about today. I mean, look, the Whiteside ambiguity rule is frankly ambiguous at best. It's a hard rule to understand. It's a hard rule for district courts to understand. But there are some emerging themes that we see come out of the cases. One is that the front label is back in the driver's seat. We've retreated from the McGinity kind of this anything is ambiguous. The back label should come into should be part of the context of motions to dismiss almost always. We're seeing courts across circuits kind of come back to the Gerber's basic principle that you can't fix clear, bold statements on the front of package with fine print buried on the back. for defense lawyers, we've retreated from this high water mark, but there's at least a predictable playbook that got and some guideposts that help us kind of understand and guide our labeling decisions and our litigation posture. And we know what judges are looking for: clear front labels and consistency across the front and the back. Um, the second kind of theme that we see coming out of this is that ambiguity doesn't mean what you think it is. It no longer guarantees that you're going to get the back labels in. Possible ambiguity, even plausible ambiguity, isn't enough. Courts are going to ask whether a consumer must look for more information. And frankly, it just redefines the concept of ambiguity. But that's why your motion to dismiss strategy needs to frame the ambiguity as necessary. Reasonable consumer couldn't understand the term without additional qualifying language. And we're going to continue to see that play out in the courts. But the qualifiers on the front. Moving to the next point, the qualifiers matter, and that's why the ambiguity rule is going to, I think, take a little bit more of a backseat, because most brands are moving towards just saying upfront what they mean by their descriptors. Whiteside gives us the blueprint on how to do this, right? Asterisks or qualifiers right on the front, close to the claim, proximate, easy for consumers to understand, particularly when you're using vague descriptors like sustainable or plant-based or natural. Don't hide your qualifiers. Use common language: by weight, per serving, as package, things that consumers really understand, and then use those same terms verbatim on the back. If you're going to say something more on the back, just don't try to rephrase it. Don't try to use synonymous terms. Just use the same verbatim qualifiers in the front and back. Whole package review is more limited now. Courts are going to consider the full context, mainly when the front is truly ambiguous or invites further clarification. We're not seeing the whole package review kind of the default rule, as we did for a very short period when McGinity controlled. So the full label defense isn't dead, but it's much more narrow now. And then finally, we're seeing the circuits aligning around kind of a net impression of the front label and whether it invites more information from the back or the side panels. And so I wanted to get to kind of what most of you are probably most interested in. Well, what does this mean for my business, and what does this mean for how I label my products? Everything we've talked about kind of comes down to that question: how do we operationalize these legal standards in a business that's moving fast and has probably tension from the marketing team and demands from the marketing team? And the good news is that we are starting to see some fault lines, and these cases are starting to create some divisions and some practical disciplines that you can build into your practice right now. I think the first kind of primary good label governance, good label compliance is just say what you mean on the front. Vague descriptors are going to get you into hot water. And so if you want to use a term like sustainable or natural or plant-based, just tell the consumer what you mean by that term up front. If you use an asterisk or a qualifier, make that additional language proximate and readable. And I think the other way to kind of think about your qualifiers is it's insurance for these vague descriptors. They convert potentially subjective words into kind of objective understandings for reasonable consumers. That's what courts want to see. That's what courts are going to be looking for: does a consumer have an objective understanding of what I mean by this term? And that's most easily done by using the qualifying language upfront and clearly. The second kind of practical advice is just be disciplined about how you're rephrasing qualifiers or additional language on the back and side panel. The back panel's job is to confirm, not to correct or contradict what you say in the front. So mirror your qualifiers verbatim, align your tone and your hierarchy, the same claim, same metric, same phrasing across panels. Consistency is going to be your credibility here when we go to the courts and try to argue that the context matters. Any sort of mismatches between the front and the back are going to trigger kind of, it's a gold mine for plaintiffs' lawyers to point out these inconsistencies between the back label and the front label. You can run a back to front consistency audit before, approving final artwork. Just literally read out the panels, make sure that the story is consistent. And if you're seeing any inconsistencies, we can kind of address that before the label ships. Design matters here as well, especially when we're using qualifiers, when we're using asterisks, size, contrast for qualifiers. An asterisk on the front label with some hidden fine print on the side is just not going to be as effective as an asterisk on the front with clear qualifying language proximate to that asterisk. Use consistent fonts and sizes. And use it across SKUs and sizes. Whiteside told us that the asterisk is a functional signal. So if one size uses it, then we should use it on all their SKUs across all products. Design and legal kind of need to be in the same room early on these kind of decisions. Compliance on these kinds of issues can't be a post-print sticking point because that's when you get into some litigation hot water, and you don't want to be going back to the design teams after you have a filed class action and trying to figure out how we align our labels. And then from a litigation posture, I know not many of you on the call are litigators per se, but from a defense side, you always want to, your best arguments after Whiteside is that the qualifying language up front was clear and proximate. If there's no express qualifying language, then you want to argue that the reasonable consumer would necessarily need more information to understand what that representation means, such that they're going to necessarily look to the back, the ingredient list, other contextual clues to understand what those statements mean. Plaintiffs are always going to try to frame these contradictions or omissions. You said natural in the front, but you had synthetic ingredients in your ingredient stack. So the cleaner your alignment, the stronger your motions to dismiss are going to be. And then document your choices. Litigation is all about evidence, of course. And so whatever substantiation, documentation you have on the backside, the compliance matters in these kinds of situations. And I think one of the takeaways, as we work with clients on this, we understand kind of the internal dynamics of the business. The marketing team wants to make, very flowery kind of promises to consumers. Legal team wants to be very explicit with asterisks up the wazoo. We understand there's going to be some balance between there, but we have some kind of guideposts that allow us to kind of figure out the best balance to kind of allow the marketing team to derive value from the descriptors they want to, but to protect and mitigate risk going forward. It's somewhat of a team sport between marketing, legal, design. We want to be collaborating early, both in-house and with outside counsel, on understanding how these marketing claims are going to be understood by consumers. One way to do this, and one way that I've kind of like to talk to clients about is, have a checklist on what your label says. Is the front accurate? Is it complete on its own? What's the net impression of the front label? How will a reasonable consumer understand this? Do you have qualifiers? Are the qualifiers proximate and clear on the front label? And does every panel align with the front's message? Would a court say consumers must look further? If not, then a back or side qualifier probably is not going to be considered. So, taking everything together, I think there's some practical takeaways that in-house teams can kind of operationalize in how you're coming up with product and marketing language. And so with that, I do see we have a couple of questions and we have a few minutes. Let me see what these questions are. So first, one of the audience members says, what if the asterisk is on the front next to the claim, but the related disclaimer is on the side or back? Great question. And not to be too much of a litigator here, but it depends. We're still seeing how that exact question is playing out in courts. I think Whiteside gave an opening to say that asterisks and arrows or asterisks on the representations invite consumers to seek more context, both on the front and on the side and back panels. We haven't seen that exact issue play out in a very clear way. The most direct way I can answer that question is qualifiers on the front are going to mitigate your risk much more than qualifiers on the back or on the side. But I do see an opening where courts may say that an asterisk invites consumers to look at the entire context of the package, and that does include the back or the side. A little bit more of a risky proposition on a motion to dismiss, but I do think that's an argument that we're going to see play out more in the district courts.
Yeah, especially in the Ninth Circuit. The Second Circuit, again, is more willing to kind of consider the side labels, the back labels, but in the Ninth Circuit, certainly you want that disclaimer on the front.
Another question we see is, do we see these principles applied in non-physical product or label cases? For instance, a claim found on a website with qualifying or correcting information found elsewhere on the page or on another page. We do, and kind of the corollary of that is we've seen some products where a brand will include an asterisk, and the asterisk directs the consumers to the website where there is a lot more information. And so transparency is key here. To answer the question directly, certainly qualifying information next to a representation on the same web page is going to be the best way to mitigate risk. But I think transparency is key, and there's a story to tell when you're being transparent. The more information you can give consumers, the more clearly you can state what you mean by a term like plant-based or natural on the website, on the label, in your marketing materials. That's the best kind of client I like to defend, because it's hard to argue with transparency. We're telling you exactly what we mean. Any consumer that wants to learn more about this can see it right here. The closer proximity you have to the representation, the better. But again, the asterisks and the qualifying language sometimes courts will say that the asterisks will invite consumers to look at that broader context, and so that certainly does come up in non-physical product cases as well.
Yeah, and a related question we just got: can disclaimers be included via a QR code on packaging? I mean, yes, we've definitely seen that. I think that's a little, questionable. Like, are consumers actually going to scan that QR code that brings you to the website? I think that's a little bit of an easier argument for plaintiffs there, even more than just like including the exact web page that you're linking to on the product label. But it's also different. Like, does the landing page that you're linking to have the challenge representation and the qualifying language is included on like the FAQ page? That's probably not as strong as having that qualifying language right there on the landing page. But yeah.
And again, I think the narrative and the story that defense counsel tells matters, and transparency is key here. In my experience, it's pretty obvious that the brands that want to be transparent with what they mean and the brands that are intentionally trying to obfuscate what they mean. And so the latter group is going to have a much harder time on a motion to dismiss. Brands that have a very prominent sustainable descriptor on their package, for example, but then talk a lot about what sustainability means to them, whether it's through a QR code, a URL link on the package, or just general descriptions of what sustainability means to them. That transparency is a better story to tell than buried fine print on the back of a label. And so I like the QR codes. I like the links to the URLs that tell you more of the story. The more clear you can be and the more transparent you are with your consumers, frankly, I think that's just good business, and it's going to drive value with your consumers and drive marketing value with your consumers. But it also has strong litigation defenses, particularly in this space that's quickly evolving.
I think with a QR code on packaging, I would probably want to have some kind of qualifying language in addition to the QR code. Like, so have some kind of disclaimer, then say for more information, QR code,
Yep.
And like have a fuller description.
One of the clients I work with right now is we take sustainability seriously. Learn more about what we mean by that at this link. So, that kind of information is going to be more inviting for consumers to visit that link if they want to understand about sustainability, versus just a URL buried on the backpack somewhere that just says, go visit our website. So the more information, the more transparent you can be with consumers, I think just the better you'll be. So with that, we've run out of time. Thank you, everybody, for joining. My email address is on the screen. Antonia's email address is on the screen. I hope it's not too obvious, but we love talking about these topics. We love talking to consumer brands. It's a super interesting area of the law. I'm always happy to chat, to bounce ideas around on how we can make our labels more clear, how we can derive marketing value, how we can mitigate risk, find that right balance on our marketing claims. So definitely feel free to reach out if you want to talk about this some more, if you have more questions, if we didn't get to your question. With that, I will close with our CLE code one more time, which is label 2025. Again, label 2025, no spaces, is the CLE code, and the CLE link is in the webinar chat. So with that, thank you, everybody, for joining. Really appreciated your participation today.
Thanks, everyone.